we indicated that we need to finish, but please don't feel pressured into finishing when you don't want to finish. We'll be willing to stay on here forever if that needs be.
I'll finish before 12. Thank you. Chair, and thank you very much for the opportunity. I won't be long. I think first let me start by saying we say no more than what's in our heads of argument. And we've given it there in greater detail than we should, and the time we should spend today, oral argument. And may I, in view of what the chairperson asked for, there is a bundle, not a bundle, it's just heads of argument with references to those specific paragraphs that the chairperson indicated lacked referencing. So we've done it in the, there may be one, I think it's 349, that may not have it because it's simply a generalized comment on the nature of the evidence as a whole. And so that is not there. Chair, before I set out the scheme of my submissions today, let me just read one of the two cases that I think the tribunal must read together to understand what the truth is about sexual harassment and what factors must be considered. But I quote this because I don't want an understanding, a line that there's another tone in our argument that does not recognize the seriousness of sexual harassment as a scourge. And it's in the case of McGregor versus Public Health and Social Development, Sectoral Bargaining Council and others.
It's the same one that...
it's the same one that my learned friend... Yes, I just want, because it starts with a very powerful clarion call to all of us. And it defines sexual harassment beyond what one finds in the two acts, the PEPUDA, and it says, sexual harassment is the most heinous misconduct that plagues a workplace. Although prohibited under the labor laws of this country, it persists. Its persistence and prevalence pose a barrier to the achievement of substantive equality in the workplace and is inimical to the constitutional dream of a society founded on the values of human dignity, the achievement of equality, and the advancement of human rights and freedoms, and non-sexism. Not only is it demeaning to the victim, but it undermines their dignity, integrity, and self-worth, striking at the root of that person's being. Writing in 1989 in its first reported case of sexual harassment, the erstwhile industrial court, sounding the alarm that sexual harassment cannot be tolerated, highlighted that, and it quotes, unwanted sexual advances in the employment sphere are not a rare occurrence, and it is by no means uncommon, close quote. Unfortunately, the truth rings as loudly today as it did then. The only difference between now and then is that today we hold in our hands a constitution that equips us with the tools needed to protect the rights that are violated when sexual harassment occurs. Yet, what this means is that for as long as sexual harassment persists, so the Constitution becomes an eidolon and its promises of equality and dignity equally elusive. You may wonder why I'm quoting this, because to a naked eye, it sounds like I'm arguing against myself. I'm not. I'm raising this because this is a clarion call to everybody involved in an inquiry about sexual harassment. And it is a clarion call to the complainant or complainants, and a clarion call to the potential respondents in cases of this nature. But of course, it's a double-edged sword, this definition. The seriousness with which we are being warned means determining questions of sexual harassment must be done in a way that is careful, that is unbiased, that concentrates on the facts so that in future you do not have a broad sweep and a system where any complaint is entertained even if it undermines the legitimacy of genuine complaints about sexual harassment. The scheme of my submission is as follows. First, that I'll deal with, noting that the comprehensive heads have been filed, is that I'll do a broad summary of this case, of what this case is about and what it is not about. And this I do to avoid repeating certain things. In that first point, I will also deal with the precise definition of sexual harassment, wherein I will argue that there is a definition because we must avoid a generalized approach, one-size-fits-all approach, depending on how we feel. And I will give the definition because there have been a lot of moral questions raised, some of them misplaced, which have tended to dominate the questioning of the respondent and the condemnation of the respondent and these proceedings, and from the large community of moral high horse riders. The second topic I will deal with is an overview of the evidence without repeating it, the tenor of the evidence. And in this point is to demonstrate, as I start within the heads of arguments, he who alleges must prove. It's a basic principle. And I will show that contrary to the broad sweeping claims and moral outrage about flirting by a judge, there is absolutely not an iota of evidence showing that that flirting, which is not impermissible, that flirting constitutes sexual harassment. And while I'm there on the definition, my learned friend chose to move away from PEPUDA, the Equality Act, because she says we must focus on the Employment Equity Act. I will demonstrate that it's actually a case of jumping from the frying pan straight into the fire. It is actually in the Employment Equity Act that the word unwelcome as a factor, unwelcomed, is mentioned 8 times. In fact, in the 5 factors that my learned friend sought to rely on, it is there that the word unwelcome is mentioned 7 times, and once in the broad definition. So basically, the two are not distinguishable in their emphasis of what it is that constitutes sexual harassment. Thirdly, I will traverse the general tone of the conversations between the claimant, the complainant, and the respondent. Of course, the point we've made here is the fact that some conversations were concealed. Obviously and ordinarily, no one expects us to be suggesting that in a complaint every point must be quoted. But what we are saying is that the pattern of what was selected reveals a deliberate attempt to conceal that which would reveal this important factor called unwelcome. And if the tribunal feels that, well, that's conjecture, so be it. But what we were raising is not that she should have quoted everything, but that the pattern of selecting itself, selecting particular things that do not really place you in a positive light, is itself a problem in proceedings of this nature. The fourth one is that in as far as there's been an attempt to suggest that the conversations are replete with rebuffs, and this is dealt with largely from page 43 to 44 of our heads. And it suggests that Ms. Mengo was an unwilling partner. It means was unwilling to engage. I will traverse, although briefly, the so-called rebuffs, which in our respectful submission are a creative reconstruction of the conversation, almost undermining the participants in the conversation. Fifth, and we do this from page 44 to 54, I will refer to my learned friend says he doesn't like the word salacious. My own client used the word sensual. I will use three of them: sexual, sensual, and salacious chats themselves. Citing different dates, for example, 8 June 2021, 10 June 2021, 18 June 2021, 20 June 2021, 21 June 2021, 23 June 2021, 26 June 2021. We cite these clearly there, and I will not repeat them, but I'll move there when I deal with the argument. And the last two topics, or three topics, and which are dealt with in page 57 to 68 of our heads, will submit that the claim that the respondent sent crude pictures is a patent falsehood. There is no evidence that it happened. And to suggest post facto that we must assume it did because we can't tell that it did not has to be said to be rejected. That it was not shown. We suggest that no evidence showed that such a crude picture was sent. And we deal with this in reference to Annexure H, Annexure H1. And as I said, this is in page 57 to 68 of the heads where it's dealt with. Annexure H8, Annexure K8, K11 and K12, K13, N and P. And we show that the evidence of the expert, Dr. Moller, does not support the claim that such crude pictures were ever sent. We will, in that topic, submit that should be rejected. And most crucially, the respondent eloquently denied it. We'll also show the futility of the expert evidence. And I think most of the questions from the chair about referencing were there. And in this one, we deal with it at page 77 to 92. It's paragraph 230 to 280 of the heads of argument. It's dealt with in greater detail there. And I will try to persuade this tribunal that both these experts failed the test that I had placed, at least we put to them, about at what point is expert evidence to be accepted and helpful to the process. And I cited the tried principles. Lastly, as a topic from page 106 to 114, we deal with what we call fabrication. I'm using the word dishonesties advisedly because I do not wish to attack the complainant there. I think the word is a little harsh, but I think we call them incongruities. I apologize for using the word dishonesties. It's harsher, and I think let's leave it at incongruities and fabrications. At the heart of this is the claim, which we say is false, that JP sent Ms. Mengo a picture of his private part. No evidence was shown to really prove this very, very painful public lie about what he did or did not do. We will also here indicate no evidence, no amount of conjecture can show that on the day of the 14th or the 15th, the incident about which the respondent has been so humiliated that he called the complainant and showed her his private part. Painful falsehood, no evidence showed, the footage did not. We will deal with those. And while I'm there, Chair, you asked the question about what was requested from the where the respondent requested the tracker of the movement of the complainant's car. The evidence leader said, no, that request was not made. Chair, there is a request for particulars that demonstrates that that happened. And in particular, you look at paragraph 1.1.3. But generally, the entire thing demonstrates that what was requested. So we will submit that it is mistaken. And in conclusion, Chair, we will show with reference to what we think are fabrications designed to conceal the fact that the conversations were consensual. And Chairperson, insofar as there were things that were said by my learned friend about which I think are attacks on us as a team or my respondent, you do not need to determine my conduct and whether I was brutal or not to determine this matter. I don't want to get there. I would like to go straight to what the issues of this case are about. On the first topic, Chair, as I said, you are not required to determine how flirting should be done. Whether the respondent does it elegantly or inelegantly is a matter about which reasonable people can differ. How it is done on what others would expect is quite a subjective question. And therefore, the suggestion that the problem is the manner is itself a wild allegation that no one can determine. The narrow complaint of sexual harassment brought by the complainant against the respondent is based purely on several WhatsApp messages between them. And in order for such communication to constitute sexual harassment, it must be related to sex or gender and must have, and this is the important part, unwanted, persistent, serious, demeaning, humiliating, and intimidating or threatening adverse consequences. The first of these is unwelcome. And none of these necessarily must be pulled out. In fact, there's one that has been added about who initiates. It's not a factor. It is not a factor to determine whether people consent in the discussion, to determine who starts it. You must look at the content of their discussion. And so it's for the reason that that factor of who initiates it is not necessarily a factor. It is the content and conduct of the parties engaged in the discussion that matters. The definition of sexual harassment as articulated, and I will use the Equality Code Act, but I will ask the tribunal to use the Employment Equity Act if it so wishes. And that definition says this. It too comes from a whole body of legitimate case law. It's unwanted conduct which is persistent or serious and demeans, humiliates, or creates a hostile or intimidating environment, or is calculated to induce submission by actual or threatened adverse consequences, and which is related to sex, gender. I invite the tribunal to look at both, even the one that I didn't rely on. It will find that it's defined this way, the key being unwelcome. This is the narrow ambit of this inquiry. We deal with this in the heads from paragraph 19 to paragraph 46 in our submissions. This is the classic case. Yes, I agree that it's an important case, but it's an important case because the very essence of the definition, the factor of unwantedness, if there is such a word, is absent. It's absent. It's concocted, reinterpreted, but that reinterpretation itself undermines the participants in the conversation. We can sit here for the whole day, the whole 2 months, trying to analyze in our own condescending way what people mean or what they meant. What matters is what they said and meant to each other. It is this definition of sexual harassment that is the gateway to all the things you've been asked to find against the respondent. How can a judge do this? A senior judge must not do this. A senior judge must not court this way. But first you must find, before you reach whether anything he did was dishonorable. Of course, I wouldn't court the way he does. I find it inelegant. But this is not a competition about how best to court. I do it my own way, or I used to before I got married. And he does it his own way. Yeah, my wife is listening here. But the point is, we are told that relationships of this nature at workplace are not a problem. It's the manner in which he engages. This is a murky area about which most men and women can differ. Some are elegant, others are not. And therefore, it would be difficult for this tribunal to get there. What I'm suggesting is this.
Some say you must buy flowers. Some say take her to a restaurant in Sandton. But in Sikhakhane, where do you get a restaurant of that kind?
You know, Chair, we say this in our heads, and it may sound facetious. It is difficult to analyze conversations of people from different backgrounds. It's much more difficult if you come from Western notions of conversation, because you are analyzing something about which you enter being superior, that you think it represents barbarism. It represents, that's why the manner, why didn't you buy her flowers? Why didn't you take her out? Inherent in that analysis is absolute prejudice and condescension about how different people approach this. And I'm not here to argue that the JP courts elegantly. I've already stated that. I don't know, but different people can approach it differently. And so to conflate what you think is an elegant way of asking one out with harassment, which is persistent and unwanted, does not find favor in the evidence that was presented before you. And so we, in the first place, ask that you consider the definition of sexual harassment, which is objective, and you look at the evidence. And that is why we preamble, or we start by saying the necessity of proof always lies with the person who lays the charge. And to suggest that all the complainant must do, or a person who must complain must do, is to simply lay a complaint. After that, we will concoct all sorts of sympathies about how they were feeling and what gender they are and what position they are, is a dangerous approach to it. On its own, as much as it's attractive, it's an attractive, feminist approach to looking at those things. It's a dangerous approach to dealing with issues that plague society seriously. And so one must develop a precedent, not just of being general about this, but to be rigorous. It's not brutal. It's to be rigorous so that we determine the truth. And we say some of it were clearly fabrications. I've already stated some of them. So this definition is the gateway to all the accusations that have been put here. Was the JP acted dishonorably. The Constitution protects everybody, and we must not quote it selectively. And one of the most important things about it, its founding principles, is that what we ask for those who are our clients, we must ask for everybody. And justice is at the center, which means fairness to both the complainant and the respondent. And so selective quoting of the Constitution is itself unconstitutional. And on several occasions, so much was said to describe this case, even this morning, as unprecedented. It's an unprecedented case. It is said to be the first complaint of sexual harassment against a sitting judge in the history of our country. So what? So that we must depart from tried principles of establishing facts? It cannot be. This idea that the identity of a litigant is a judicial way, is a justification for departure from tried legal principles, is a dangerous route to take. The idea that law is an elastic that we must pull to where we want is itself a plague in society. We must be strict about defining things. As we show in these heads, and I want to, the description of the litigant being a judge is unhelpful in determining whether the factors that constitute sexual harassment are present. They are not. Zero. And we start the overview to show this, which was my second topic, with a legal doctrine, res ipsa loquitur. And I use this, although it's a Latin term, but it's a legal doctrine. It's a Latin phrase for this. The thing speaks for itself. Now, when we are analyzing and say what they mean, we keep vacillating from whether a woman can say no, and no means no, to a point where we are not sure if yes means yes. And it's because we lack intellectual honesty to deal with this so that we can cut out possibilities of sexual harassment that is clear, where people are exercising power to prejudice others, men or women, but largely women. We must never, in our determination of any matter, sexual harassment, murder, or anything, reach a point where we are not rigorous because we fear that we will be called misogynist when we are thorough, we will be called brutal. It is actually the brutality, the rigor that we must apply that will determine what it is. And the first thing is to look at what happened.
I must say this. When you talk about the no and the yes, I think the record will show. I asked Dr. Vetten, a no from a woman means a no. And she quickly said yes. And then I said, conversely, a yes from a woman means yes. She hesitated and gave, the record will show, and gave a qualified answer to that. Yes. Surely a no is a no, a yes is a yes. And we must respect both, isn't it? We must, where a woman has said no, we must respect her intellect and capacity to understand that and respect her decision to say no. Equally, where she says yes, we must respect the yes and not rationalize it.
Chair, I was going to use that example, but I mean, it's a question that was asked, and I must quickly add to this question because I know what the groups that condemn us for brutality will say. You see, it's not untrue that in where power relations are unequal, people use that power to force others to do things they wouldn't do. That's why the definition talks about an adverse and hostile environment. But it's not there for the taking. Your objective facts must show that that power was abused. The fact that that power exists on its own does not demonstrate its abuse. And what we've been told here several times is that the power relations are unequal. But of course, they are unequal. My wife is not a senior counsel, I am. The power relations may be unequal. What you must determine is whether there are objective factors before you that demonstrate that that equal power relations, if they are unequal, was abused to create a hostile environment. None of that exists throughout this conversation. What is there is a reconstruction, reinterpretation of what she may have meant. And I say this with all due respect. This tribunal must deal with this, with all the truth and the facts that are there. If the chairperson asks me, for instance, I make the submission that I think in the face of a very hostile situation, not environment, and many people expected the respondent, actually, and most husbands would have, to duck and dive on these issues because they are embarrassing. None of us in this room would like our WhatsApps to be read, even to our wives or husbands. We wouldn't. So it's an embarrassing environment already. But, except maybe for one incident, I think the JP entered the terrain. Yes, it may be called arrogant, bullish, whatever. Well, this is the environment. But the fact of the matter, he cannot be accused of being evasive and lying. Not once did he deny that he wanted a romantic relationship. Most people would have denied. Most in this room. He would have ducked and dived. I'm not even certain that he dealt nicely with the question of the banana peel, but that's just me. I just think we must be able to be honest about shortcomings in a case. But the general tenor of this, between these conversations, if truth be told, is conversations between two people. Things may have gone sour, but we have no evidence why they went sour. And at no point can one, on the objective facts, without interpreting biblical meanings, that there was a rebuff, that someone was told, don't. And I mention this because a lot, we are presented as some kind of, there's an undertone from us of misogyny, whatever it is. It's not. This case is about finding out what exactly was the conversation about between the two. We may find their conversation disgusting, but it was their conversation. None of them was forced, and it's immaterial who would start the conversation about sex position. It's about what was the tenor of their conversation. Is the unwillingness there? And we will submit that it was not. We also state that when the complainant filed the complaint, the pattern of what he did not incorrect. That's not what we're suggesting. But if you look at the pattern, it is where she herself is being flirtatious or agreeable to the flirtations. It's not lawyers for complainants and everybody involved in litigation. I think you don't have to be a lawyer to know that truthfulness is correct, is a virtue. You don't need a lawyer to tell you that when you are reporting something, try and disclose something close to the full conspectus of what happened. So the idea that because there were no lawyers somehow diminishes the ability to tell the truth, bizarre suggestion. And so we say that the text messages themselves do not reveal unwillingness. Annexure K8, areas about which I think my client has gone through serious embarrassment, purporting to be a picture of the alleged private part. He's still insulted on this, called by this, something no evidence was shown. And we don't make this point to trivialize a complaint or to threaten future complainants. future complainants who have a legitimate case and know that something happened to them will state it. The tribunal will remember that I asked, and I referenced this later. First, no picture of this nature was sent. But let's ask for a moment if it was. Had it been? And I asked do you know his private part? And the answer was no, correctly so. Because there would be a difference between sending a sordid, crude picture of a penis, a private part, and sending his. And where I fault the complainant, and it's no attack on her, and that's why I removed the word dishonesty, and all I'm saying is that if both, and I said it at the beginning of this hearing, that both the complainant and the respondent will never be the same after this. Because a private conversation between them made it to the public domain. Both of them. And it is subject to being judged. But it's also replete, well, not replete, it has occasions that did not happen. And how do we know they did not happen? First, we deny them. Two, the accuser cannot show them. Nowhere in these proceedings. So the respondent, as I said, never requested nude pictures, for instance, of the complainant. Not once. We are told that he asked her to show umtla, which is the upper body, and I think that's there for itself. And what is important is whether that conversation itself was a conversation that meets the requirement, the factors of sexual harassment. We say it doesn't. No matter how disgusted we are about the conversations, those of us who are perfect, no matter how unhappy we are about the inelegant way in which they were presented, no matter how many high horses we ride from our moral place, the fact of the matter is that that we are not happy with how the two conversed is not an issue for this tribunal and was not an issue for the JP to meet. So my suggestion is that the entire conversation, the general tone of the conversation, the content of the conversation reveal two willing adults who are engaging in something that most of us may find maybe we don't like, but consensually they engage in it about sex positions, about all sorts of things most of us pretend we wouldn't do. That is not the case to determine. And of course, the other point, we've been accused of abusing culture. There's no abuse of culture. It's the point I made earlier. It is difficult to analyze a community of people from outside. First thing, when you are not in that community. But it's worse if you assume superiority of your own culture and way of doing things. It's what we say in our heads. One of our criticism of the expert and how this case is run is to pretend there is a universal truth about which everyone can agree about coaching and flirting.
Mr. Sikhakhane, I only want to ask, this was never put to Ms. Mengo. She was never granted the opportunity to deal with this Xhosa culture. And I accept that it's different from any other culture. I accept that, but it was never put to her, and she never got the opportunity to tell us what he knows about it.
I think you're right, Judge. And this is the area where I'm analyzing the expert. That the expert, you will recall that when the expert was introduced, the evidence leader told us that she tried to find a Xhosa culture person. And so the significance of that submission is that that was correctly so with the evidence leader, because she has kept very professional about what she's saying. Correctly, she understood the danger of entering a different culture from a position of knowing the universal truth and being superior about what must be done. And so I accept that. And you will recall that when I tried to engage Ms. Mengo, which she was doing perfectly, I was stopped from getting into the relations, critiquing the expert on the question of culture. And it's not a fact that must be put to a witness. It's an analysis of experts and her legal representatives. That it was not put. Cultural analysis, we were bombarded with the so-called relations. And so one has to engage, is prejudicial. And so of the paper she quoted, she quotes. And we are told later as well that at some point of the conversations, the complainant amassed courage to confront the respondent. Now, how do you assess that this is implausible? Is that you've got to assess the point of when this courage visited her and what happens thereafter. But if you look at what happened, is that at the time of this attack of courage, it comes and then it goes. And she continues with discussions with the respondent that are still sexual, flirtatious, and in our view, consensual. So we submit that the complainant could not explain how her newly found courage quickly dissipated, and they continued with discussions that are flirtatious. One would expect that once someone has made up their minds that this ends and stops here because I don't like it.
You are referring to
the East London.
The period after the rebirth of intimacy.
Absolutely. Is that, quite frankly, it is condescending to suggest that at all times when we deal with these cases, there are moments when we must regard the woman as some kind of child that is unable to stand her ground, and sometimes we must believe her. I think the objective facts will show when a woman or a man, usually women, are in that situation, we would not be guessing as we are doing here. It becomes very clear very early that we say somebody persisted, and therefore, because they persisted, even if the persistence was not unwanted, constitutes sexual harassment, is an abuse of the legal principle. Because persistence or persisting itself cannot be isolated from the important fact that this was unwanted. Or this was consensual, I'm sorry. So her version that at some point she rebuffed is not borne out by the facts of this case at all. And the last issue in my summary of this is it's difficult to deal with the so-called incident of the 14th or 15th of November because we prevaricate. We don't know whether it's the 14th or it's the 15th, and we are told it doesn't matter. But it does. It does if one reads the entirety of what was presented to demonstrate the whereabouts of the complainant and the respondent. To say we must guess and suggest what is probable is a principle we must apply if things are unclear. The accuser has not placed before this court evidence that what happened, what she claims happened, happened. The evidence of the footage does not show, even if you wanted to do on a balance of probabilities, that it happened. It was submitted here that because we can't really know, we must assume that there is a space there where an opportunity of it happening is there.
When the secretary must have gone to the toilet.
Yes. I think it would be a bad precedent, frankly, Chair, to decide in a matter of this nature that we must decide on somebody's guilt and impeachment from their career on a surmise. Well, because there is this time you could have done this horrible thing. It's unfair to everybody to suggest this is gross misconduct claim for which the complainant and her legal representatives want his career to end. And I think if his career must end, it must end because objective facts and evidence are there so that we don't regret later. Nobody must be sexually harassed, but nobody must be falsely accused of sexual harassment by two adults who may have changed their mind post facto. Another misconception that is here is that we must ignore I was stopped by the chair during the cross-examination when I was painstakingly showing the similarities between the initial complaint, so-called initial, and the complaint before us. To reduce it to that, it shows that she remembers because she is consistent, is truly something that deserves no response. The point we were checking at that is that she had first said she had no access to the initial complaint. And when I took her through not just grammatical errors, spacing, full stop. In fact, I was going to spend the whole day doing it until the chair stopped me because it was so identical.
Were you surprised that I stopped you?
No.
You even showed a misplaced full stop in the one document was equally misplaced in the other document.
Absolutely.
So.
Chair, and what it demonstrates to us, and we must be truthful about these things. And if you place to me something that I think my client didn't handle well, I'll tell you. As I've already said, there are one or two things like I thought I wouldn't do, I wouldn't say this. But I think it's important for this to realize that first lying or telling a falsehood to a tribunal in a matter of this nature is itself inimical to constitutional values, because so much can happen out of this case. So much. Somebody's case may end. Career may end. And it is equally important that we are fair to the complainant. I'm not asking that she must be ignored and that future complainants must be frightened. But I'm asking that rigor must never be taken out of legal processes because we fear that certain groups will attack us. In fact, the best way to protect this is to demonstrate to both potential harassers and potential complainants that this is a serious matter about which nobody should come unless they know their story. And no respondent, including my client, no respondent must come to be evasive. And I deny the fact that she was evasive. He was embarrassed, but advised properly, and he did it himself, that he will speak the truth about what he did and what he meant. And lastly, the invocation of power dynamics is a range topic that we deal with. And I think I don't deny, no man must deny that power relations are a factor in harassment of any kind, both sexual harassment and harassment in general in global politics, in personal relations. But to assume that at all times power relations must dominate how we assess evidence that is before us is itself a dangerous approach to determining cases. There's a big case in this country where a determination is made by describing that the litigant is such an important person. We already have a case like that. Therefore, we will depart from tried principles. And I think it's for that reason that I emphasize that we stick to what is objective, what was put before this tribunal. Because it is only through that we can reach the other point, whether the conduct was honorable, whether it's conduct unbecoming of a judge. You must first, on what is before you, determine whether the gateway to that honorable, dishonorable honor, which is sexual harassment, has been met. And so in pursuit of these allegations, so much is said about the respondent that he behaved indecently. We've put in to show that nothing was shown in this regard. And so we demonstrate that this complaint of sexual harassment is entirely contrived. And this statement must not be misconstrued as undermining what sexual harassment is. My learned friend already said, nobody is saying that relationship in an environment of work should not happen. And I think linked to that is that nobody can suggest that flirting in a particular environment, any environment, is impediment. If you meet that, if you find, Chair and the members of the panel, and the evidence shows that they were unwanted,
the respondent persisted with them.
And the respondent persisted with them, of course you have to find that, because that's the clear definition of sexual harassment. You know, there's no way of me running away from that legality because I want a client to survive. The fact of the matter is that there are things, if the objective evidence drives you without being selective, you see the problems that this case is argued. Sometimes we must look at the context, the entire conspectus, and when you're there, you are told, yeah, but there may be a no somewhere in between. Don't look at the entire conspectus. The fact of the matter is this: objectively assessed, if this tribunal finds and pulls out clear rebuffs, communication to the respondent that I do not want you to continue with these conversations. If you find conduct of that nature or statements of that nature, you must assess them carefully and rigorously. And of course, if you find that they were unwanted, it will be difficult for you not to find that sexual harassment happened because you're right within the frame of the definition. It would be dishonest of me as a lawyer to try and wiggle out of that. All I'm saying is that the tenor of these conversations, broadly analyzed in their context and objectively analyzed on the content, on their content, do not demonstrate unwillingness. And if all the things that are quoted, some biblical, the eyes and all of this, if they are interpreted to mean these conversations of people who are melting, who are choosing sexual positions to each other, were not consensual, we're in a dangerous path. We're in a dangerous path about future determination of matters of this nature, which are very serious. And so, as I said, the complainant dedicated several paragraphs to demonstrate that she may have rebuffed, she meant this. When she said hi, she meant this. We submit that nothing in the conversation objectively looked at, you don't have to reinterpret or reconstruct them, demonstrates a rebuff, nothing whatsoever. And where I say both the experts, in my view, and I think I put this to them, the role of an expert is to truly assist the process. We could have found a witness, a misogynist male who wants to come and defend another man. It wouldn't have worked. We could have found a professor who probably would come here and be disgusted about this complaint. That's not what an expert does. And it's for that reason that we could, as much as we try, to find someone who would assist is difficult. One gets tempted to find someone not to assist the process, but to assist the client. And my suggestion about Docrat, and it's said, I'm not talking about them in their absence, is that we find that their evidence leaned not in favor of the process, but in favor of reconstructing a case for a litigant, for a complainant. And so
it may be argued that regarding Docrat,
yes,
to some extent, less so.
Chair, I think so. I think so. I think to be fair to where I fault Dr. Docrat, and I don't think it's, one could say it's lack of intellectual dishonesty or anything, is that it's something any expert can do. I think less so for her because, and I think it's the point that was made, is that when you don't have the entire record, that's the first thing. And two, in your attempt, you give an import to an emoji, for example, because that's, as an expert, what you think, but it's not what the two parties understood it to be. So I think her evidence tended to give an interpretation contrary to what may have been the understanding of the parties. So I think less so for her, but
despite that, at the end of, this was the end of her evidence.
yes,
He said, however, I will concede that the meaning and understanding of the messages by the parties will be as understood between themselves, not me. Something like that.
if she did,
I may be summarizing here inelegantly, but
yes,
in the end, she said, who am I to say they should have understood this message this way and that way, if they, between themselves, really considered and stood aside for a while.
In fact, even Ms. Vetten, the deficiency of not having the entire record, back at their evidence were correct. And so, Chair and members of the panel, I will take you the evidence, but I do not want to repeat. And in that narrow ambit, who initiates is not there. It has particular factors that you must look at. And I say this because there's a loop. You are forced to jump and look at how can a judge do this? It's not nice. It's not your gateway to that analysis. In order for you to find that the respondent did not court properly, don't know what courting properly would be, or acted dishonorably, you must first find that this complaint meets the definition, the fundamental definition of what he was brought here to answer. That's a fair way of looking at it. If you were to ask me that we must have a theological discussion about what I would do as a Catholic or what a Seventh-day Adventist would do or people of a different sect, it's a debate that we can have. But it's unfair to have that debate if you jump over the definition. And if you fall short on the definition, you cannot move to whether the conduct was dishonorable, because that analysis is a jump to subjective questions about which nobody in this room is an expert. And as I said, the Constitution recognizes that judges, like all individuals, enjoy the rights first as human beings. And it's not, when we say freedom of association, we're not trivializing this case. We are saying we are in the realm of two adults courting. And so to impose our subjective judgments is very nice, because we are people, we are judgmental, we ride a moral high horse. It's a nice thing to do. It makes us look better than the rest. But that's not the test. The test is a fundamental definition of what he was brought here to answer. Humiliating him or citing things that didn't happen to evoke emotions in society about what did not happen is itself an unjust approach. And of course, we submit that, and we do this in from paragraph 32, much more, where we say there is no residual misconduct complaint here outside the definition of sexual harassment. Nothing. And it's for that reason that we actually, when one witness who ventured into character evidence came, our witness, about Ms. Mengo. And I think the tribunal was correct to stop it, but that too must guide us in how we analyze this case. To meet the definition of what he was, all of this or about us being brutal, it doesn't help the case. All I'm saying is that there are objective factors to be determined on this. And so, unsurprisingly, as we say in our heads, the judge president responded to sexual harassment charges only, to that charge. We could have spent time debating other things, and there was no space for that. And there is no, it's unnecessary, it's not relevant, because we're venturing into things that are subjective. The test, as the evidence leader said, we look at, it's objective. We have the evidence. If there was no evidence, you would be permitted to venture into other things of interpreting. But if the accuser is unable, or nobody can place the evidence of what they say happened, it's difficult to charge people with conjecture, not in such a serious matter. Not when we are suggesting something so serious about another human being. And so he was not called upon to meet all of these cases of what is the right way for a judge to court. Can a judge who's judge president court a judge who's not judge president or someone who's working? It's a different case if we were to meet that, but we're not called upon to meet that. And it's a difficult case discussion to have because it's mingled in subjectivity. And as I said, the act, I don't even want to go to the sexual harassment policy, the recent sexual harassment policy. Because law works that way. There's always an improvement of deficiencies in how we do things. And so to suggest that we must look into a system that is trying to deal with the future in analyzing what happened is a... I know that while it's being used, we are told no, but yes, it doesn't apply retrospectively. But I think even reference to it is immaterial. It's not helpful. And we deal with the cases of Mutata and Hlophe and Kindred, and we think that reliance is misplaced for this case, quite frankly. And I don't want to bore the tribunal with things. We deal with that from paragraph 47 to paragraph 56. And I wouldn't like to repeat it because I've also dealt with what are the applicable legal principles. And I said when I started chair in the tribunal, there are two cases that are interesting to read about this, because it is reading both of them that will guide taking a fair approach to the complainant and a fair approach to the respondent. It's the case the McGregor case that I talked about. But I think the Amatole District Municipality case that we've cited this, but I will give members of the panel the proper citation. It's here. Both of them are important. I started with the one that defines the scourge of sexual harassment in society. But the Labour Appeal Court in this one, not that it's unaware of this scourge, deals with a complaint that was deficient. A complaint where no evidence of what is claimed happened is shown. A certain Mr. Fredericks is accused even of something as disgusting as one of the things the respondent is accused of here. Exactly the same. The complainant says, no, he called me to his room, to his office and asked me and showed me his private part or asked me to perform oral sex. And the court finds no such evidence exists. Not that the Labour Appeal Court is unmindful of the seriousness of sexual harassment, but it engages on each case on its own merit. That is one of the most cardinal principles of determining a matter, rather than a broad sweep that assumes that nobody in life lodges a false or a mistaken, erroneous complaint. I said in the beginning that I don't want to attack Ms. Mengo, and I keep using these words because it's possible in error to do something. And that case, the Amatole case, demonstrates better because the judges in that case do go to great lengths to describe even the deficiencies in the evidence of Mr. Fredericks. But assessing objectively the entire evidence, the key areas did not happen. They go as far as saying you can't call a witness reliable when they pointed out things that did not happen. And in that case, they find that the fact that there was reference to things that could not be shown happened. Because if we cannot show that something happened, what are members of any tribunal left with? Conjecture. And if we're going to bring conjecture and assumptions as an important component of legal precedents, it's a terrible precedent. And our courts will be imperiled by an approach of that nature. So from paragraph 57, Chair, to paragraph 68, you will see that we deal with just the definition of sexual harassment, and I don't want to bore you with that anymore. And then we deal again with, in 3 topics, we show that sexual harassment claims here are based on the WhatsApp messages, all of which do not demonstrate sexual harassment. Second, we traverse WhatsApp messages and we find no evidence that crude pictures were sent. And the third topic, for which no evidence has been, these are 3 legs of this, only 3 legs of this complaint. Text messages, a crude picture, and lastly, the so-called incident of the 13th, 14th in the respondent chamber. All these 3 legs of this case have not been shown. None whatsoever. What we're left with is guessing what could have been. And I submit that you can never decide a case of this nature to impeach anyone when those pillars are absent. And so we deal with those topics, and I don't want to repeat them, Chair, because if you take our heads from paragraph 71, we then quote verbatim, and from paragraph 72, we also deal with concealed messages. We can differ about what the objective or intention of concealing was, but all we know is that in their entirety, those messages about which we've been concluding that she was a willing participant, all of those were not there. This, coupled with what I pointed out in the two complaints, that in keeping with the theory that the complainant is a timid employee, junior employee who respects authority, in the complaint she removes a paragraph that would have demonstrated her belligerent behavior towards a court manager. And that pattern of concealment demonstrates that every communication or aspect of what happened that reveals what contradicts the theory of a complaint was removed or concealed and put up later. And so we deal with that in great detail until, I think, paragraph 100. And the topic there we deal with is
Question, even before we came here, this case as having been omitted.
Yes.
I know I met them somewhere, but what I want to know for sure is that they were translated or interpreted, all of them.
Yes.
Okay.
Yes, I think eventually they were here. They're here. There's no suggestion that they're not here. But it's not insignificant that a witness does not give you at the beginning everything, that you must extract it like a tooth, either in cross-examination or when the matter goes ahead. The important principle about complaints of such a serious nature is that they must be truthful. And defenses themselves must be truthful. Because anything short of truthfulness in determining a matter of this nature is a dangerous legal principle. It doesn't matter what I think. It doesn't matter what my learned friends think. It doesn't matter who we sympathize with. Lack of truthfulness in determining a matter of this nature is not an insignificant factor in assessing the evidence. Because it contaminates. Let me give an example. If the respondent had come here, instead of agreeing that this is a sexual discussion of a sexual nature, as most men I think would have done to duck and dive, is, yes, this is romantic. Yes, this is sensual. Yes, this is sexual. Because that's the truth. It would have been utterly dishonest for someone who's called a judge president to try and duck and dive. And so, truthfulness is important, even if you are not perfect. It's important when you've put a matter before a tribunal to be truthful. And this is no suggestion of perfection. Both these individuals are imperfect, but they're here, and you don't have to be perfect to know the importance of truth. And from paragraph 101...
Mr. Sikhakhane, can I ask you one question? I'm sorry.
Yes.
In the event we were to find that Ms. Mengo, in some part of the testimony, she was untruthful. Let's talk about the second complaint. That she must have had a copy of the original complaint when she made the second complaint. If we are to find that she was untruthful, does it mean then we have to reject all of the testimony, or we have to be selective on each and every item we are called upon to decide?
Thank you. I don't think so. I think it's a tried principle of arguing. It would be absurd of me to suggest that when a witness has in some way fallen short, you must reject everything that they say. I wouldn't say so. I don't think so. But I think what you must do is to assess the pattern. If that kind of untruthfulness is a pattern, well, you must decide as the tribunal, what is your attitude towards falsehood? What is the impact of falsehood in our legal culture? Because once you introduce the fact that it's insignificant to have a pattern of fabrication for a witness, well, you're on dangerous territory. But all witnesses, particularly women in circumstances like this, or anybody, including my client, humiliated, when you are in a setup of lawyers and judges, it's not unknown to panic. It's not unknown not to be certain. And so where instances of Ms. Mengo or my client being uncertain, I do not think that is something for which you must reject everything about. I did cite an example. My client talked about, I had thought the banana peel really is a sexual, and she said, no, it's like a chocolate. I was entirely unhappy with that reference, and she explained it later. But I'm saying it's important that we don't reinterpret everything and the truth to conceal, because then it doesn't help the tribunal. All we are doing is just defend our clients. And I'm saying to you that if you can find, for instance, that there is a pattern of lying from my client, you have to reject it as evidence. You have to find that he's unreliable, but there isn't. But there's a pattern in Ms. Mengo of concealing what would have given a different impression. It's entirely false that she didn't have the two complaints. You don't have to be a lawyer to see this. It would be embarrassing for anyone to suggest otherwise. If she were my client, I would have completely told her, I don't accept this. And then from paragraph 101, we deal with the alleged rebuffs. And the essence there is that there was no rebuff, none whatsoever. Everything that is called a rebuff is an interpretation. We need to sit and debate it to agree that it's a rebuff. A rebuff from someone who's being harassed, at some point must be clear. At some point it must be clear. And what we've been doing is to try and reconstruct what she meant when she said I and other things. And the no's that we tried to, I'm still waiting, I'll see the 13 no's. But there was no no that actually, or I, that was not subjected to interpretation. And so we have to engage in that to know that a person says no. And the fact that we had to do that means the evidence does not show us that there was a rebuff. And the evidence shows that Ms. Mengo was a willing participant in these sexual conversations throughout. And I cite there that she didn't do, but it's the 8th of June incident, where she too flirtatiously replies. And I say this at the beginning, it is of no moment who initiates. Some ladies do initiate these days, I'm told, and it is of no moment who initiates. The content of the discussion between two people is what determines whether one is being harassed or one is being inappropriate. It's the incident of the 16th of June, which indicates that there was some discussion that were general, that was sort of inspiration. Of course, this is omitted as well because it does not form part of the theory that all that was happening was harassment. It's the incident of the 18th of June where both of them engage in that discussion. We will remember the quote, especially Rento, to which she reacted on the 20th of June. Yes, it's been trivialized, the fact that she wakes up in the morning to greet him. Happy Father's Day, Jola. We make no moment in it, except that we add that if you look at the entire tone, this is not someone who is fed up or unhappy with this engagement. It's not consistent with someone disgusted and unwilling. And the reference at 24 minutes past 10 about being cute from her. And following something that says, when Ndens are shy, you make me shy. On that day, including a discussion at 26 minutes past 10, where they're talking about East London. These are people who are engaging, and no outsider can interpret it differently. And so, yes, it was trivialized when it was put to the expert that when people are engaged in courting, in discussions of this nature, toing and froing is the essence of the game. It doesn't matter where you come from. Toing and froing. The word persistence is being abused in these cases sometimes. You know, persisting in a way that is unwelcome, of course, constitute harassment. But persistence, pleading with someone on its own does not constitute harassment. I would not have been born if my father didn't persist. It took years. And I'm saying persisting, not in a violent way, unwelcome way, in certain cultures, in fact, in certain cultures, if you agreed quickly, immediately, prejudice against you is visited. People think you are cheap, you lose. I'm just saying, it's important that you analyze the nature of the persistence. Unwanted, causing an hostile environment. But to generalize that persistence or pleading with somebody is itself a sign that one is harassing, is a simplistic way, an unrigorous way of understanding fully how people engage. And on the 21st of June, another discussion happens. We deal with it at paragraph 135, and I wouldn't like to deal with that now. And we deal with those, Chair, up to page, I think, 57. And I would like the tribunal to go through those unless there are questions as to whether, and we put references in those. 1367. 137, yes, sorry. Paragraph 137, sorry. That's on the 23rd of June, right? And we see also a discussion there where they're talking about the blood warming up. All I'm saying is that all of these chats to which we've referred here constitute nothing close to sexual harassment, even loosely defined. And the evidence we've set out there shows at no point. That's why we are at pains in this room to try and reconstruct, reinterpret, play psychologist to what could she have meant, in what state was she, was he. It's not important to do that when you have evidence or you have no evidence of what is claimed. Chair, let me deal with the respondent briefly. I submit that in the face of a very humiliating environment I don't mean in this tribunal, of anyone having to accept that a conversation of flirting is made public, the respondent was generally truthful, accepted at all times that she sought a romantic relationship, that the discussions were sexual and sensual. If you have to assess the two witnesses, I think the respondent, on the objective facts and admit what happened, truthful, reliable. The questions about other questions that were irrelevant about it, but you are a married man and all of this, I think those were stopped in the tracks because we have to look at what happened. And so I think he denies justifiably all the incidents. He denies that there was at any point. In fact, in some discussions, she actually checks with the complainant if she's unhappy, but there is no unhappiness throughout. Chair, we deal with that, and
I don't know how important is the argument that you are a married man in a country where you can marry 3, 4, 5 wives.
Chair, it comes from, it comes from a temptation. It's a human temptation. I'm a Catholic, and I have a temptation to think everybody is Catholic. And so I bring Catholicism as a universal truth when I analyze things. It's a human temptation to assume that your morality, your own morality, your understanding of things is universal. And as I keep saying, it's worse when it's applied from a position of someone who believes they are of a civilizing tribe. The other one is inferior and barbaric. It tends to complicate the subjectivity of things. And you're right, Chair, in an environment like that, someone has to pursue somebody first in order to decide that they want a second one or a third one or a fourth one. As we know, I think we've only gone to 4 as the experience in this country. But my grandfather had 9. I never know. But I think it's a dangerous analysis, and it's an imposition of a particular worldview.
It deals with morality, which does not find. We're not here to deal with morality.
It deals with, but Judge Pretorius, it actually doesn't even deal with morality. It deals with what I call a worldview. Because if you say it deals with morality, inherent in that suggestion is a suggestion that there's something immoral. It deals with a human temptation to refuse other worldviews of how people see the world, the ways of being and ways of seeing and ways of doing things. And that's where we are. And that's why we have this debate about some snide attacks on culture and people. It's because basically we are failing to be intellectually rigorous about different facets in society and how people see the world and how subjectively we see the world and how we're influenced by race, by class, by gender, and by class. If you ask me, would I court like the JB does? No. Is that significant? No. There may be 2 million ways of approaching somebody. I wouldn't kneel down. I never did. But most people do. Okay, sorry, Chair. I got it wrong. Chair, it's those, and we deal there with all the annexures, with Annexure 8, with Annexure H1 and H2 to demonstrate that some of these evidence of the 17th of June, for instance, that there was an image of a man muffing a woman. She relies on Annexure H1, H and H1, and it also makes reference to H2. We say Annexure H, for instance, does not depict what she says it does. And so most of these accusations that are very serious do not find favor in the evidence, and we have to reconstruct it, engage in some psychological gymnastics to get into the minds of litigants, and it's condescending and wrong if the evidence is there or not there. And Annexure 8 as well, we deal with it. We deal with K12 and K11 and 12 that relates to the 27th of June. That's the most important. And this is probably one of the most humiliating accusations, that no evidence was put before this, that the JP sent a picture of his private part. You have to hate him to believe this, even when the evidence is not there, because it's the most humiliating accusation against someone, and you can't show that he did. We deal with Annex K13, JP. Sorry, I keep saying JP, but I think you don't lose that title. Chair, may I move to the cases we rely on that I have said? First, I don't want to deal with them. We set out a series of cases that deal with the principles of expert witnesses. And I think I've dealt with Dr. Docrat and Dr. Vetten. I don't want to belabor points about what was deficient, and I do not want to sound like attacking them in any event. All I'm saying is that their evidence fell short of the tried principles for a witness to assist a process of this nature. And so we deal with the different cases there, and we've cited them. I think it's the Kindred case is different because the judge was the employer, actually, that American case, apart from the fact that it's irrelevant and one could look at it if it offered any help. But we've said here, and we know that as much as we accept that the JP is powerful, he is no employer. And that's the difference there about, and the other cases then it's the Price Waterhouse, I would like and the AM and another versus MEC for Health, and the Dupree's case. In those cases that we cite, we say demonstrate that both Ms. Vetten, where they fell short, the fact that they did not have the entirety of the record, which would have made their evidence more useful. They did not engage in that. And so we say here that most of it, maybe not by design, their evidence, particularly Ms. Vetten, became nothing but conjecture and her own subjective views, and sometimes borrowing from her experiences in some of the very important work she has done in legitimate cases of sexual harassment. Unfortunately, she was imposing that interpretation in a matter where the set of facts is not consistent with her experience, where women are bulldozed and women have been harassed by people who are powerful in a workplace. All she was saying is true. It's just inapplicable in this case. We all know how women are subjected to sexual harassment in different environments. Unfortunately, this one-size-fits-all analysis by a witness is itself a dangerous legal principle. And so we deal with that, and I do not want to belabor that point. I cite, without repeating, examples. They are not exhaustive of my engagement or the tribunal's engagement with the experts. And I think the evidence there is clear for both Ms. Vetten and Dr. Doctrat. The last issue is, again, I've mentioned this. We deal with this from paragraph 281. Page 92 of our heads. It is this incident. It's as serious as the one about sending a picture of the private part of the so-called effect on me incident. We submit, Chair, that if you look at those dates and the vacillation between, it's not insignificant, that vacillation between the 14th and the 15th. We demonstrated that this changes at a particular point. And you see, at that point, it looks like it's a spray gun approach. I'll shoot and see what I kill. For instance, it would be insignificant to draw the distinction between 14 and 15 if on one of those days, at least, there is evidence that something happened. It would be petty to say, oh, it didn't happen on 14, but it did happen on 15. There is no evidence placed before you. To ask you to assume that there was an opportunity that it could have happened is a far cry. And it's a principle that must never, ever be applied in determining whether someone must be impeached or not. And so we submit that that embarrassing complaint about that incident, as prejudicial as it is, never happened. And no evidence was put here that it did. Can we deal with that bit towards the end, and then we cite all of those, and we say in the end from paragraph 292, members of the tribunal, that the objective evidence, which is a point I've been making since I started, the objective evidence negates Ms. Mengo's allegation. Nothing before you sustains the three pillars on which the complaint. If you are called upon to decide that flirting is injudicial, that flirting is dishonorable, well, we plead guilty because this was flirting. But you are not called upon to make that. And the two other incidents did not happen. No crude pictures. Objectively, we know there was none. And the so-called effect on me incident did not happen. And the footage does not show it. In fact, it is the respondent who provided his movement on the day to try and demonstrate where he was. He could account for where he was, and to suggest that because his clerk may have gone to the loo, a finding must be made that he did such a despicable thing is a far cry, is absolutely a far cry, because nothing shows it. And we deal with that towards the end, and we analyze Ms. Ngai's evidence, we analyze all the witnesses, and we think there is no suggestion by anybody. It's unfair to suggest that any of those witnesses were lying. Even our criticism of the experts, it would be untrue to say they're lying. I think it's some kind of what I call inchoate analysis of events and less intellectual rigor in assessing the benefit of both the complainant and the respondent fairly and objectively what is before it, what actually happened. You can ignore my interpretations, but I submit that what is before you does not sustain any of the three pillars of this very serious, very humiliating, sordid saga. And unless there are questions, Chair and members of the tribunal, we ask you to find where the evidence takes you. And in our view, nothing takes you to sexual harassment. It takes you to something that is subjective about what we think a judge should be, what we think a married man should be, what we think a church elder should be. We can differ about that, and how we think people should court. I don't like the way Matt Donzella courts, but that's his choice. And so I am saying to the members of the tribunal, we do not trivialize sexual harassment. It's a serious scourge. And it's for that reason that I'm asking that you are rigorous in assessing what was put before you. It's much more important than our own interpretations. I submit, therefore, Chairperson and members of the panel, that this complaint does not meet the standard of a legitimate complaint. Thank you.
The tribunal may not release you, any one of the parties, before a certain time. We are not in a hurry. to release you as long as there are some issues we feel need clarification. And to that end, we may have to adjourn for some minutes, cup of coffee, and come back again. But that said, I don't know if, for now, members of the tribunal have questions to you, Mr. Sikhakhane.
Mr. Sikhakhane, I'm going to ask you the same question I asked your counterpart.
Yes.
The issue of a photo. Was there any photo from the complainant which was sent to the JP?
That issue is dealt with in our head because it was a photo, not a status picture. It's a photo that was sent
Thank you.
by him.
By the way, what page of your heads of argument?
Chair, let me check how we can. If we are going to adjourn, can I come back with the precise page where we deal with that aspect? Because I think my learned friend, it's a dispute. It's what it is, and I think the tribunal must find on looking at it. Does our explanation suffice? And if it doesn't, well, it doesn't. But I think it does. But I'll come back with that.
Thank you.
In fact, may I use that opportunity as well? Is that as much as I said that was the end, to probably confer with my colleagues during the break, and if I have anything to add, may I be permitted to do so? But in case they scold me about the deficiencies in my argument.
Check paragraph 110 of your heads of argument.
110.
Yeah, paragraph 110.
It's 1-1. Yes. In fact, I marked it's on the incident of the 8th, where the complainant testified that she never sent the respondent pictures directly, but she did.
Okay.
We've set that out, and that it's a dispute, it's a matter. Then we've presented what we say in that paragraph, and the witness, the respondent, dealt with this question. And if his explanation is in the eyes of the tribunal insufficient, well, a determination must be made, but that's the answer. But I'll deal with it if this is not enough.
Thank you.
I think that's all we can say about it. Thank you.
Thank you.
May I just ask, I know there were some discussions, maybe on different occasions, about the deletion of WhatsApp messages between them. That issue was discussed between the parties. Delete, don't delete. Why did you delete before I read? Delete so that your children may not see, and so forth and so on. So I'm asking this question. Was there an agreement between the parties that messages or some messages be deleted?
Can I broadly, there is reference to where one asks, are you deleting? And the other says, I am, right? Or I do delete, or I've deleted my message, or they go to. I think the only moment for that is that it just shows that both were mindful that their private conversations would be embarrassing if someone saw them. I don't think it's on its own, it suggests anything else, but it's part of what we've submitted. These were two adults who were aware that their discussion was salacious and that nobody wants that kind of discussion to remain on their phone, just in case somebody else sees them. So I think it just shows that there was some meeting of minds until some point when the complainant decided to publish them. But I don't think it's relevant for determining. Yes. In fact, that I've just been shown that there are messages where one asks, "Are you deleting this?" Says the complainant, asking because he says everything has a name. But I'll try and get and the JP says message deleted. I'm not accusing anybody. I mean that, but what it just shows is that they both did not want this footprint. Nobody does, of a conversation that is so intimate, that is so private. And I don't think that could be used either against one of them. I think both of them were mindful, like any adult would, that there is an embarrassing element in an intimate conversation becoming available for all to see, even amongst people who do the same. And that's what I called, we're all riding a moral high horse because we've not been caught. But generally, people are embarrassed about their private conversations becoming, and that cannot be used against Ms. Mengo only or against the respondent. I just think it's the general conduct when people are engaged in private, intimate conversations.
One small matter. I don't recall.
Oh, by the way, Chair, the other issue I wanted to raise, because it's raised, it's a topic we deal with, but I think it's that kind that because he apologized, he therefore admits guilt. Yeah, I think it's a misplaced interpretation of an apology. You know, an apology for someone who's a judge when...
Is there an argument by anybody that communication between the two parties stopped at a certain point? I'm asking this question because in your heads of argument, you refer to a yes lapse. Can you explain that, please?
Yeah, I think there's a gap in the conversations until November.
Just your mic.
From February 2022 to November, there is a gap. There is no conversation. Yes.
Let me write that. A gap from
February to November 2022.
okay. From February. Do you have the date?
That's fine. But the other incident where they communicate is insignificant. It was about using the JP's office. But
Yeah.
for relevant communication,
Yeah.
we say there is a gap of this kind of conversations from February to November
That 20...
2022. February 2022 to
20.
November 2022.
22.
Yes.
Is he giving you instructions?
No, Chair, it's just reminding me of something, but I think we've covered. That's I think there is that gap, but there is a communication about an office using chambers, but I don't think it's significant in any way.
Advocate Bartlander? Or should I perhaps start with you, Advocate Skippers? In possible response to some of the issues raised by, which are new?
I don't have a lot because I know Advocate Bartlander has a few, but I think there's only one thing. It's not correct to say there's no evidence supporting the complainant's version that the disputed messages was sent. She testified on that. So that is evidence that must be taken into account. And it's not correct to say that Mr. Moller's evidence does not prove the fact that it was not sent. It also does not prove that it was sent. It's neither
Yes,
here nor there.
No. But that was in response to Advocate Butlender's categorical statement in which, in her heads of argument, she says, the evidence of Mr. Mola supports the fact that supports the complainant.
Yes, but it was now argued that there's no evidence that the messages were sent. That is not correct because there's viva voce evidence on that by the complainant. There's no proof. I agree to the fact that there's no concrete proof. But Mr. Moller cannot say whether or not it was sent because he cannot say from the evidence that he has here who is the sender and who is the receiver.
Yes, but
because
then
it was deleted.
Should we say that Mr. Moller's evidence supports the complaint?
I cannot say that it supports it, but it also does not disprove it. Yes, it's neither here nor there.
Well, it's a matter for consideration. Advocate Butler, anything that arose from the heads of submissions?
Yes, Chair, just a couple of things. But before I do that, I understood that Mr. Sikhakhane wanted to perhaps keep going if he took instructions.
He's finished.
Are you finished? Happy?
Yes,
okay.
I am.
Chair, a few things. The first thing is I had referred the tribunal to the Judicial Services Commission Act and what's required of a complainant. The relevant provision is section 14 sub 3, which requires a complaint to be made on affidavit, must set out the nature of the complaint and the facts on which the complaint is based. That is the requirement of a complainant. Mr. Sikhakhane in his address referred to this issue of what was attached to the complaint and what wasn't. And he suggested that the additional WhatsApp had to be extracted like a tooth. There's no suggestion that anything had to be extracted like a tooth or otherwise. It's not an accurate reflection of the facts. What happened is Ms. Mengo was asked for her phone as part of these proceedings by the evidence leader. She provided the phone. In fact, she preserved the evidence for this process. The judge president chose to delete all the evidence. One might ask what was there to hide? If this was purely a consensual, flirtatious relationship, why delete everything? But the simple point is there was no pulling of teeth. There was no difficulty. She was asked to provide her phone and she did. On the question of deleting, which came up just towards the end of my learned friend's address, my learned friend suggested that there was agreement between them that they would delete. There was no such agreement. The judge president asked her if she was deleting, and she said she was, and that he asked at several points. And the first time she said yes, because I don't have space on my phone. And the second time she said yes, but in fact she did not delete. She'd never deleted anything. It's all there. So when one looks at the WhatsApps, you see that the deleted messages come from the respondent, not from her. He would send a message and then immediately delete it. And in fact, she asked him, why are you deleting? But there was no agreement between them that they would delete this. And so the suggestion that there was some kind of a meeting of the minds on this is not correct. In fact, it's a reflection, I would suggest, of her knowing that there was something in those WhatsApps that he was doing that was wrong, that she was preserving. She was uncomfortable with this. So there's no agreement. On the issue of culture, we're now told that the cultural argument is not a factual argument, but it's an intellectual one, and that's why it didn't have to be put to Ms. Mengo, and that it amounts to our response to the cultural argument amounts to cultural superiority. But in that very context, we're also told that we didn't have to ask Ms. Mengo for her views on this. We are accused of treating her of infantilizing our client, but we are the ones saying she must be asked. What is her view of her own culture? What is her view of the culture that she's supposed to have been, a cultural practice she's supposed to have been participating in? So there's a great contradiction there. Why does only the judge president get to explain to this tribunal his views of the cultural practice that he says they were both engaged in? Why was she not given that opportunity? It's not sufficient, I would submit, to say that this is not a factual question. It is a factual question. And it should have been put to her, and it was not. The effect of allowing this defense is to say, in the absence of her commenting on it and being given an opportunity to comment on it, is to say that this tribunal must rule on a question of what is said to be her culture as much as it is his, without her even being asked. So let's be clear. Our submission is this argument was an afterthought. It was not raised in the respondent's affidavit. It was not before the JCC. It was not in these proceedings until the very last witness brought by the evidence leader. So we would submit that there's no merit to the argument. Mr. Sikhakhane then says that it's unfair to make these decisions on probabilities, and it's a principle that must never be applied. But that's precisely what the Act requires this tribunal to do in Section 26.3, is to make a decision on the balance of probabilities. It's a civil standard. There's nothing extraordinary about that. You will evaluate the evidence on the facts as they are and make a decision on the balance of probabilities. Then we kept hearing that there is no proof. The respondents kept saying there's no proof. But there is proof. There may not be proof of certain of the explicit sexual photographs. We accept that. But there is proof before you. There's evidence before you. There's an entire file of WhatsApp messages that are the source of the sexual harassment. And one can't throw the baby out with the bathwater. One has to look at those WhatsApps, and one has to engage on what Ms. Mengo says she considered to be sexual harassment. Now, on the suggestion that it is of no moment who initiates sexual conversations, it's correct that that's not a factor in the determination of sexual harassment. That's correct. But it is notable, and it is a factor to be taken into account in determining whether or not, in determining the probabilities of what the complainant says. Because if there was just one instance in which the judge president initiated a conversation with a sexual basis, that may be one thing. But where every single time a sexual conversation is had between these two parties, it is initiated by the judge president, every single time, then that's something that gets us much closer to sexual harassment. It's a factor then that this tribunal must take into account, together with all of the factors that we've discussed today. On the Kindred case, I'm not sure if my learned friend has had occasion to read the case, but the judge was not the employer. The whole point of the case is that the individuals who were sexually harassed were clerks in the court. They were employed by the court system. I'm not sure who it is in the United States, but it's the equivalent of being employed by the OCJ. So they were not employed by him because he was a judge. And the case is relevant because it concerns the relationship between a judge and his subordinate, who was an employee of the court. So in addition, the allegations against him were sexual in nature. They involved the sending of sexual text messages, and the court found that he was guilty of sexual harassment. He resigned before the next stage of the process took place. Those are the issues that I would like to address, unless there's anything else from the tribunal.
sorry. The,
Thank you, Ms. Patlender. Just one question. I already asked you that question. The 11 no's, where are those 11 no's? Are they the highs, or when you say the 11 no's, where are those on the WhatsApp?
We'll provide you with a list of all the instances that we count.
Okay.
They are not just high. They are all the instances in which the complainant rebuffed the respondent, either by saying no, specifically using that word, or by saying hi, or by referring to a Bible verse where the first word she pointed to was no. Those are all the instances in which we say, she was trying to say to the judge president, I'm not interested in this. But we will put that into a table form and provide it, and I'm sure if the respondent wants to respond, that he would be given that opportunity. Thank you. But it won't be argument that we present. I would literally list the instances and the reference to the papers, unless the chair would like something different. Okay.
perhaps what we would like to raise perhaps may be a question to you, Mr. Sikhakhane. Because you said something about what the respondent is facing or not facing. This advance which the respondent initiated was during working hours and at a workplace. Shouldn't that be frowned upon, irrespective of whether subsequently the complainant agrees to the advances? Shouldn't that be frowned upon if the judge president makes advances to the complainant at work during working hours? If that is frowned upon, that may be the next leg in which you may participate. Advocate Patlender may also participate. Would that in itself be, if that is a misconduct, but would that amount to a gross misconduct? And if you're ready to answer that, if the parties are ready to deal with that, please do so. But if you want us to adjourn for 5 minutes, we'll do so. But that is the thing that we want to ask you, that forget the fact that it was the judge president. We may even ask the question, would it not be frowned upon if a manager makes advances to another manager at work during working hours? Would it not be frowned upon if Ms. Mengo is a clerk, isn't it? A judge's clerk. If another clerk, a male clerk, equivalent to Ms. Mengo, would it not be frowned upon if that clerk makes advances to Ms. Mengo at work during working hours? Consider, leave out the question of power relations. Yes, I think that.
Yes, Chair, the answer is no. No, it wouldn't.
Sorry?
The answer that whether the timing when people engage would be frowned upon or constitutes sexual harassment, the answer is no. Because something must, I think,
I didn't say it constitutes sexual harassment.
okay,
I said, in fact, I said,
frowned upon.
even if it's frowned upon, it may not amount to sexual harassment, but at worst, maybe misconduct. But I said that I didn't opine that it could amount to
Sure.
gross.
I get you.
Yes.
Yeah. Chair, I think the timing of when people communicate, I know that some argument was made about if it's after hours, that communication is inappropriate, therefore it must be within hours. I think the timing of when people engage on its own is of no significance. What is of significance is exactly whether that communication interferes with their function or is an abuse of time, resources, and power. But whether someone sends a message that says you are cute at 8 in the morning or sends it at 8 in the evening, I do not think that debate about what's frowned upon is of any significance about the timing, unless it interferes with time and it creates a particular work environment that is defined as hostile.
Yes. But I think I should mention this. I went through the messages, WhatsApps that were exchanged and the like. I can't even count them. But there's one thing that struck me about this. It's that 99.9% of those messages were exchanged after hours. Anybody can go and check. 10 o'clock, 9 o'clock, early hours of the morning, by both of them. But outside working hours, I've looked through them. And I recognize that fact.
Sure.
But the point that I was asking was, you have spoken to it, was the concern that irrespective of whether the JP or what, is it right to take the time at your disposal at work to make that kind of approach? Well, you have spoken to it in the way that you have. I don't know whether you still want to add anything before I move to.
I don't want to trivialize it. I think you see, this is why I said when we start looking at how, and I think the sexual policy may be trying to do that, is that it's difficult to try and look ahead at what is deficient in our definitions of when, and I think we'll keep improving this. What is unfair is to charge people as we think ahead. And I think that charge of what is frowned upon is a subjective consideration. And in this case, and I don't want to make any point about it, yes, they were after work and all of this, but I think what would be important in future is to look at much more clarified, and I think maybe the policy now does, clarified ways of what conduct cannot happen between people who work together and what conduct would constitute sexual harassment. And I think that's why I call some of it conjuncture, is that we're trying to look ahead, and sometimes it's correct, but that's how policy making happens. But to try and speculate about what would be frowned upon in the future must be expressed in policy, because it's very subjective how people frown upon what different. That's why I called it a world view factor. and the things that some of my colleagues do, and I frown upon them, but that's just it is. It's my background, it's my worldview. Doesn't make it unlawful. Thank you, Chair. But if you look at those messages, yes, they are after work and all of this, but I don't want to suggest that our case is made by the fact they are after work. I think our case is the fact that they don't constitute sexual harassment. Flirting is not frowned upon. Everyone who condemns it does it. It's not frowned upon in society. We don't like it when it comes out in the public, but it's not frowned upon. Thank you.
Chair,
Advocate Butland.
thank you. It's correct that all of these conversations happened after work hours, on weekends, public holidays. That is the basis. It's a big part of why we say this conduct was problematic. This conduct was problematic because here was a judge president engaging with the clerk, a secretary, after hours, but also starting off that conversation by talking about work.
But
So,
what people do after work, is it any of our business?
but yes, it is. And the code for
If the
judicial...
judge president on a Saturday morning, good Saturday morning, meets one of the clerks at the mall, and then they start talking along those lines.
Yes, there's nothing wrong with that. But that's not what he was doing here. He was engaging in sexual conversation with her that was unwanted. So what matters here that it was after hours is because it took the workplace relationship into that after hours space. So here she...
No, but they were not talking about work after hours.
They did talk about work after hours. There are many
But that's not the
messages.
essence of the complaint, is the sexual discussion after hours.
It is the pattern that we say happened, that he would start by talking about work and then move into sexual conversations. So absolutely, it is critical that that happened after hours. It is part of the pattern. But on the question that the chair asked about whether we frown upon something or not, it occurred to me that, one, we're not asking the tribunal to make a conclusion of whether something is frowned upon. It's about whether or not this constitutes gross misconduct or not. But it occurred to me to point out to the panel that to the extent that that the panel considers that what it has before it does not amount to gross misconduct, but it amounts to misconduct, then it may say so. And that has happened in other decisions of the tribunal. That would then be taken into account by the Commission in due course when it receives your report, and it would then take into account under Section 25B, 20 sub 5 sub B of the JSC Act, to whether or not to impose any other remedial action or remedial steps that are referred to in Section 17.8. So that is also open to this tribunal.
It won't be the end of the matter.
It won't be the end of the matter. Thank you.
I think we are finished with the submissions. We will reserve our report, our decision, and submissions have been made also relating to the issue of the court of public opinion. I think if it is necessary to make that point, we will make it again, that we are going to decide this case in accordance with the law and the facts of this case, and not in accordance with the court of public opinion one way or the other. We are totally unmoved by the court of public opinion. And there has been, as Mr. Sikhakhane indicated, this way and that way. And surprisingly, even people who were supposed to know better just wrote articles and said something about whether or not somebody is already guilty or is not guilty. But we can assure the parties that we are not going to consider this case according to slogans or not according to slogans, or we are going to decide it according to the law and the facts and the evidence placed before, irrespective of whatever court of the judgment of the court of public opinion may be. For that reason, we will adjourn and give ourselves time to consider the matter and then issue a report. And that said, it remains for us to thank the parties for their contributions and effort and time in trying to resolve this matter, which is not uncomplicated. Advocate Butland, thank you very much.
Thank you, Chair.